Recording now. So I want to welcome everyone to the Housing Subcommittee meeting of the California Paraprofessional Program Working Group. It's been a while since this group has met. We have a number of new members that have joined since the last meeting. So I'd like to go ahead and take roll. Falmouth.
Here.
Judge Harper.
Here.
Hardston.
Here.
Sarouche. Don't think Fariba's joined us yet. And Spyro.
Here.
Okay, great. Thank you. And I apologize that I didn't send out the last memo earlier. And I also do want to check to see if we have any anyone who wants to make public comment. Looks like we have at least one person. So why don't we go ahead and start with public comment. So Beit Tzedek, you can begin.
Good morning, everyone. My name is Jenna Myra. I'm a directing attorney at Beit Tzedek Legal Services in Los Angeles. We represent tenants in unlawful detainer actions as well as other issues related to rental housing. We also represent a large number of homeowners with issues regarding title fraud, scams, and other legal issues that threaten their equity or homeownership. I know this subcommittee hasn't met for several months and has a number of new members, so I'm mostly here to listen and learn what the committee is currently considering. But I did want to raise quickly just two preliminary areas of concern that I hope this committee will fully consider. The first is on clearing title. I noticed that in the June 2020 report, the recommendations, rightly, I think, were that quiet title actions not be something that paraprofessionals be permitted to do. I think that's very wise. Quiet title almost involves fraud, which has a heightened pleading standard. It almost always involves fairly intensive witness testimony, and I think it's just not well suited for non-lawyers. I'm not, frankly, really sure what clearing title means, separate and apart from quiet title, but I did notice that in the recommendations regarding the pilot program, clearing title was listed as something that paraprofessionals be permitted to do as part of the pilot. So I would like this group to have further discussion about what clearing title means and if it's really distinct from quiet title. And if it's anything like quiet title, I would strongly suggest that it not be included for the reasons I stated about the complexity of those matters. The second point I wanted to raise is something that's been raised before in other meetings, including recently by Professor Solomon from Stanford, which is that I entirely agree with the June 2020 report from this subcommittee that legal assistance for low-income tenants is sorely needed. It's a huge area of need within the state of California. I am quite concerned, though, that the paraprofessional project as currently conceived is not going to close that justice gap really at all because of the for-profit nature of paraprofessionals and the fees they would almost certainly have to charge to make it worth their time. Most low-income tenants at 125% or lower of federal poverty, who are the bulk of tenants who need assistance, are not going to be able to afford a professional of any kind, whether that's a lawyer or a paraprofessional, without some significant fee caps or other arrangements. I'm also concerned that if paraprofessionals represent landlords, that will only further increase the justice gap, because now instead of having both the landlord and the tenant being unrepresented, you will have the landlord with representation and the low-income tenant still without. So I would urge this committee to take a careful look at who this kind of housing paraprofessional representation might actually assist, and to keep in mind that while the need is quite great for low-income tenants, I don't believe that this paraprofessional scheme is going to make much of a dent in that particular justice gap. And as I said, may also make it worse. I would note finally that the Minnesota pilot program, which I think is quite a good one, and I know members of this committee have looked at it, they specifically excluded representation of landlords from a housing service that paraprofessionals are permitted to undertake. So I would like this committee to give that some careful thought as well. Thank you so much for your time, and I look forward to listening to what you all have to talk about this morning.
May I say something? I'm wondering if Jenna can stay on and we can discuss some of this with Jenna, because she's certainly an expert in the field.
I think that's fine. I think what what I was hoping we can do first is to just recap where we are and talk about how we want to move forward. And then maybe if we want to get more into a substantive discussion, we can bring Jenna back. Unless, Jenna, if you can't stay for very long, if you want to let me know that. I muted you again, but if you want to let me know if you're not able to stay very long by raising your hand, then we can pursue that now. But if you're able to stay on, then I'd like to just start out with a recap and setting the groundwork. Okay, so, and we don't have anyone else who's indicated that they're interested in making public comment. So again, I want to apologize for sending out the memo this morning rather than earlier. But I hope you had a chance to at least scan it. And I have just summarized very briefly, this is what was voted on, or this was what was adopted at the meeting in June. And it was the working group adopted the recommendation that was made by this subcommittee in June. The memo goes into a lot of detail about information that was considered about the need for representation. And I think a lot of that came from the Sergeant Shriver Civil Justice projects. And the other thing with regard to this, as you can see, the recommendation specifically pointed out that issues related to civil right to counsel should be considered. And so with that in mind, these are the counties that have the Shriver projects currently in place. And that can be compared with what's being considered right now in terms of the pilot rollout that was adopted at the meeting on Friday. Of course, there was a discussion that the geographic rollout might be adjusted based on additional information, but I thought this information might be useful as your subcommittee discusses where you want to go. And the goal is at the April meeting for this subcommittee to bring a recommendation that does similar to what we saw. We didn't have a chance to go through it, but what happened with the recommendation that the Family Law Subcommittee is we're going to be reconsidered again in April, is the detailed tasks that are like what's involved in an unlawful detainer, the specific tasks, and what would be included and excluded. And the same thing with this clearing title. So that is what we need to accomplish for the April meeting. So I thought we could talk a little bit about what information your subcommittee would like and who they'd like to hear from in order to move us along toward that goal.
Linda, before we get to what info we need, do you have any record? We don't, I don't, and Julie doesn't. But anyway, do you have any record or memory of our subcommittee saying that there would be no landlord representation? If this came up at the Friday working group meeting.
I don't believe that was a recommendation from this subcommittee to not include landlords.
Me too.
Leah, do you have any different recollection of that?
No, and in fact, I think that you explicitly rejected that concept based on the fact that there are small landlords. There are lots of different types of landlords, some of whom may have difficulty accessing counsel.
And in fact, we were urged at the time by Bonnie Huff of the Judicial Council not to make any such recommendation. And it was never in our minds or brains or intention to make that recommendation. And we didn't.
Good morning. This is Fariba, by the way. I just want to say I'm here. I'm sorry to be late. And on this particular issue, I think also this program has got to be neutral we cannot, it's not a legal services program where, we're going to only decide to help one side versus the other. Aside from all the other points mentioned, I just want to point that out too.
So this is Amos. Do you mind if I make a comment to this? So I think in one of the other practice areas, debt collection or consumer debt, there was a recommendation about which side. Obviously, it's all preliminary still. There hasn't been any final decisions, but I don't think it's something we necessarily should exclude from consideration. In my understanding, although I wasn't part of it, I did listen very closely to the presentation to the full working group, but I wasn't part of this subcommittee before. My understanding was the recommendation was for further consideration, but no decisions have yet been made or recommendations made about what should be included or excluded. And that's really what we're tasked with doing.
And Amos, was that a representation of debtors only? Was that the line?
Yes, for most of it. I think there was one area that I think there's still going to be further consideration for, small claims court, like, enforcement of those judgments or something like that, which would be the creditor side. But I think there is at least a tentative recommendation to limit it to debtors.
Yeah, I remember hearing that more than once.
So I just want to clarify in terms of there hasn't been a recommendation that was voted on by the working group. I think Linda's previous slide is what was actually voted on by the working group. And then I think if this group wants to consider the issue of limiting representation to one party, that would be sort of an additional recommendation. I do suggest there's a difference between collections agencies and small landlords or people that have someone renting a room in their home. So I'm not sure that's the right parallel.
Okay, I was going to add that I've been really struggling with the representation of landlords as well. And I can tell you in our county, we have, again, I'm from a really small county, very poor county. A significant amount of our landlords are paycheck to paycheck. They're using that rent from their rentals to pay the mortgage on that. So a significant amount of landlords are self-represented, as well as the tenants. But to what Janice said in the public comment, I've really been struggling with that as well, is that if we have a paraprofessional program that represents landlords who can afford a small fee, the tenants, for the most part, are not going to be able to afford a fee. So we're going to be put in a situation where our paraprofessionals are going to be representing landlords and not the tenants, which is not going to do anything regarding this justice gap. We're still going to have tenants coming who are unrepresented against now landlords who cannot afford attorneys either, but now have a paraprofessional because they can afford their lesser fees. So it's something I've been really struggling with as well.
Yeah, and I just wanted to comment that I don't think that has been decided. I think we get to consider that, because I think that's right. A lot of the Shriver report that this committee relied on and quoted from in their initial recommendations, the Shriver project was all about balancing the playing field. So to not have one side represented and the other side not, which is a big part of the injustice gap. And so I think we just, I'll keep an open mind, but I just don't think we should close off the consideration of potentially limiting representation to one side or the other.
So what further information would you need in order to come to a recommendation on this topic? And who would you want to hear from?
Can I? I'm sorry, I have my hand raised.
Oh, sure.
Thank you. So I just wanted to say that, at the self-help center, the court is, of course, neutral. So we can't come out and say, okay, we only will help one side. But our court has authorized that in terms of complexities, we can limit our services. So commercial landlords, we don't help. Landlords with multiple units, we don't help. And it ends up that the landlords that we help are the type that already were mentioned. Grandma has, has a house, has had a house for a long time, or somebody who sublet or let somebody sleep on their couch. So for the most part, the landlords that come our way are those landlords. And the other thing I wanted to mention, the legal services agencies out there that help with these issues are only helping tenants. So these landlords that I'm mentioning that come to our office really don't have any other place to go, and they don't have the money. So I think that once we get into talking about tasks and issues, just like we did, like, for example, with family law, I think we're gonna come up with a way to kind of set limits in terms of which landlords, in a way that is fair and not prejudicial to landlords, and just cutting them off altogether as a category of clients.
And I'll say, I believe the Shriver Civil Council project does allow representation for landlords that qualify. That also is a project that is a partnership with the courts, and the neutrality of that program is built in. I don't believe a lot of landlords make it through the other qualifications because there are income guidelines, but I think it would be very helpful to hear from some of the Shriver program attorneys or supervisors about how that has worked out, and sort of the dynamics of representing landlords in the Shriver Civil Council Act project.
Linda, do you see folks have their hands up?
Oh, sorry, I didn't. Okay, Ira?
As far as info that we need, well, for instance, in general, information about how many, what percentage or something about how, about landlords who fall below, say, 200% of the poverty line or whatever we decide, and tenants that do. I have a feeling that, based on what Judge Harper said, that that there in his county, which I think is a low-income county by and large, it may be that more landlords are low income than in LA County, for instance, or Marin County. But on the other hand, there are nonprofits in Los Angeles, at least two, I think three actually that I can think of, that have sliding scales for tenants. For, in other words, a lot of their work is free to tenants. They only represent tenants. A lot of their work is free to tenants, but some of it is paid by tenants. And it would be good to know what information about how many tenants pay, how much they pay. I said this at the meeting Friday that I do volunteer work representing tenants, and 2 out of my 8 clients I know could afford, well, they could afford to pay something to a paralegal, maybe enough to have representation by a paralegal. They have jobs, they make decent income, not anything big. Let's see, and if we could possibly get any information that, other than what we already have, which isn't much, about how many, or what percentage of tenants are unrepresented, what percentage of landlords are unrepresented. This June 30 report that Linda put up, I remember working on that, and I've looked it over again, and there is some information there. It's not enough, but there's some information there about that.
And what we've found with the information from the courts, the GIPSIS information, it doesn't break out unlawful detainers. So we don't really have that information. everything, it's civil is just lumped all together. So unfortunately, we don't have that just for unlawful detainers.
I don't mean to dominate this, but there is a grad student, PhD candidate, whose work is cited in this report, who's continuing to work on, he's studying evictions in, I think the LA courts, maybe other courts too. I've talked to him once, and he may have updated his information. I could find out, anybody could.
Okay, great. Thanks.
Oh, sorry.
Julie.
There's a hand raised, sorry.
Yes, Julie.
Yes, thank you. I may be the only one here, but I would like to talk to somebody who is very experienced in unlawful detainer actions to ascertain the various steps of that process, because I'm unfamiliar with them. And my goal there is to emulate what the Family Law Subcommittee did and to come up with a list of tasks that we think paraprofessionals could reasonably handle versus not. Also, Jenna, in public comment this morning, raised the issue of the difference between clearing title and quiet title. I don't know that either. And so I would like to talk with somebody who is an expert in property liens. What we were talking about when we drafted this memo back in June was simpler things, more like when a subcontractor slaps a mechanic's liens on a property, and oftentimes that lien stays there beyond the need for the lien because the subcontractor eventually gets paid. Sometimes the homeowner doesn't even know the lien is there and doesn't find that out until they go to try to sell the property or take a loan out on the property. And so those are the kind of more routine liens that we thought a paraprofessional might be able to participate in lifting rather than the whole quiet title thing. And I think if you look at the very last paragraph of our memo, we said we don't anticipate them filing quiet title actions. But I still need somebody to discuss the difference between quiet title and clearing title and their view of whether a paraprofessional could participate in that assistance.
Okay. Amos?
Amos, sorry.
Yeah, so I think that's a really good point. To the extent that we are considering things like liens on mechanics, liens on real property, that might be something that the consumer debt and general civil practice area might do, because that really fits in with some of the debt collection activities. So that might be something better handled by that committee that also is, I think, scheduled to meet. The other thing, I totally agree, we need to hear from housing attorneys, experts about the different tasks. I think we shouldn't limit it to litigation. I think there's a lot of pre-litigation work that happens in tenant cases that could really avoid eviction filing in the first place. Habitability issues is an obvious one, but there are many others that I think could avoid the need for a filing where a paraprofessional might be helpful. So I'd love to have an expert describe those things. I do want to make a comment for the slide that's up. With regard to representation at trial, issues related to civil right to counsel should be considered. I think I was at least partially responsible for that language being included from the full working group. That was not meant to be a geographical issue with the pilot project. The issue is there clearly is a huge justice gap and need for representation in eviction cases. But there also is a movement, I would say, a groundswell around a right to counsel in eviction cases. And I think we need to hear from people both in the Shriver Project, but there's also others working on a right to counsel in San Francisco and Los Angeles. There's a right to counsel in New York. And I think my concern that is reflected in that bullet point is that this working group and the state bar not do anything that undermines the right to counsel movement. but supports it. And the concern is allowing paraprofessionals to represent tenants in eviction cases might unintentionally undermine what's happening with the recognition that counsel is needed. The effort to balance a playing field, for example, it may not be a balanced playing field. It might be more balanced, but not a balanced playing field with an attorney versus a paraprofessional. So we'll just have to we'll just look into what tasks we're recommending. But I think as a separate consideration, I would like to hear from people that are familiar with and part of the right to counsel efforts in Los Angeles and San Francisco about what this working group and the state bar can do to make sure we're not undermining those efforts.
Thanks. Ira?
I just wanted to say one thing, mainly with Jenna. As far as clearing title, at least what I think we had in mind back when this June 30 report was written was getting rid of liens and other problems with the title in short of litigation. Investigating the title, finding the documents, and negotiating with the lien holder. Also possibly assisting a lawyer in getting the documents necessary for a quiet title. So.
Ira, I think, so you're just sharing that, your understanding, okay. Any other information needs? I am speaking at 11 with a judge up in Ontario, Canada, where their licensed paralegals do represent parties in housing matters, I believe. This is something Jason Solomon has also referred to. So that I think is going to be a great opportunity to see if they have any data around this lopsided representation, if that's what they're seeing, because they do collect data from their licensees via an annual kind of self-assessment and an audit, essentially. So if it looks like there's anything promising there, then that's something I'll bring forward.
And it looks like Jason Solomon is among the attendees and has raised his hand. I don't know if we want to go back to public comment, or it looks like Amos, you raised your hand again.
Yes, thanks. Sorry, this relates to the pre-litigation, I think, or things that are not in the UD action. I think also reflected in this committee's prior report and in other surveys about housing issues is security deposits is a big issue. And that's usually handled in small claims court. But I think it's probably, if there's going to be paraprofessionals handling housing cases, I think we should investigate whether they could also be helpful with those non-specific eviction issues, but other, real concerns that a paraprofessional, I think, could potentially be very, very helpful in. The other comment I wanted to make is Fariba and I are also serving on the regulation subcommittee. One of the open issues is fee caps or some regulation of fees. I think that is harder in the family law context that it's been discussed in, but in housing, it might be particularly important. There's a lot of flat fee attorneys out there that provide, for a flat fee under $1,000. I don't know what the going rate is now, 750, 900, whatever, for landlords to evict. Tenants usually can get a full scope attorney for a low cost. Maybe if they know to look for them, this is sort of the education gap, or they may be able to get free legal services. If they can't get free legal services, or maybe an attorney available for a cost that can be identified a little easier than all the various tasks in family law. The eviction case is a particular set of things that need to be done. And so there might be a lot more information, and it might be much easier to get a handle on what a reasonable fee would be to handle, a security deposit issue or a defense of an eviction or a habitability issue much easier, or at least there'll be more information available, I think, to our committee if we want to consider if there should be, some sort of fee caps.
Julie?
Yeah, I might be repeating the conversation here, but in addition to getting information from practicing attorneys who specialize in UD, if there are judges who preside over a UD court, I would be interested in hearing their perception of whether a trained paraprofessional could step in and assist plaintiffs, landlords, whoever.
Other than Judge Harper.
I do. I have done unlawful detainer cases, yes.
You do?
I do, yes.
I'm sorry, I didn't know.
There's only two judges up
Only
there,
two
right?
judges, we do everything up here, so.
Yeah.
Great. Well, we'll use you then.
Well,
Myra?
small county versus big county, I'm sure much different experiences, so. Sure, what they're doing in LA and what we're doing here are very different.
There are a lot of attorneys that I know in Los Angeles. I'm saying shut out to my phone. Who could give the information about what goes on in unlawful detainers. So could and just about any attorney. Well, any attorney in the housing part of that setting. Oh, and then I wanted to add, Amos, until 2020 with COVID-19, I'm pretty certain that, and it's my experience, that it was not feasible for tenants to get lawyers to represent them in lawful detainer cases unless their income was low enough to qualify for legal aid. And even if it was, I believe that legal aid couldn't serve anywhere near the number of people who sought their services, even for evictions. You walk into the unlawful detainer court, they have there's special courts for that. There's a special master calendar court for it, and others. And the huge majority of tenants when they are not represented. I've gone there myself and a couple times and volunteered to represent people for nothing. It's a little better now in LA County and maybe in one or two other counties now that lawyers are volunteering to represent tenants during COVID-19, but that'll only last so long unless there's a civil right to counsel or something like that.
Amos?
So, yeah, so no, I agree with you. I think there is unquestionably a huge unmet legal need in representation of tenants in eviction matters. I'm in Los Angeles. I think we're lucky in Los Angeles. There are a lot of legal services programs and other attorneys that might provide, low cost services, but even in LA, there's a huge unmet need. And of course, it's a big state. I was just talking with, I wasn't trying to address the need for legal services. I was addressing the need for fee caps or some regulation of the cost, because tenants aren't necessarily better off if they spend thousands of dollars to get an answer filed or for some sort of limited representation. But they are better off with representation. I think there's no question about that. Whether it's limited representation or full representation, they're going to lose their case if they don't have legal assistance for the most part. So I did not mean to suggest there's not a legal need. What I mean to suggest is, for example, there's legal services. Obviously, that would be free, but even in LA, as examples, there's other organizations or law firms that are like Eviction Defense Network or BOSTA that provide either a flat fee or some sort of sliding scale fee that would be, less than 1 month's rent on average, I would say, that they would pay for full scope representation. And the concern is we get a licensed paraprofessional that would provide services, but it might be way overcharged, and they might be able to find an attorney for less. And that's, I think, the risk that Fariba and I are struggling with on the regulation subcommittee. And I think in particular in the housing context, it might be something that we can gather some information about.
Amos, just so I'm clear, the information you want us to gather or what kind of flat fees are being charged now?
Yeah, so if we're going to be looking into regulating fees of paraprofessionals, it would be what is the, what would be a lower cost than what? What is what attorney is available reasonably? Again, I think it could vary from county to county, but I think, for example, in LA County, it's been a few years. I used to be at a legal services organization in LA doing eviction work. I think the going rate was, $500 for a flat fee, and a sliding scale for people who couldn't afford that to get full representation through Eviction Defense Network or BOSTA. Again, those numbers might be a little bit dated. Also flat fee on the landlord side. I think those flat fees didn't apply if it went to a jury trial, but anything other than jury trial, I think it's a flat fee for all the eviction work. So I think it would be helpful to gather that information. The one other piece of information I'd be very interested in hearing is UDAs, maybe hearing from a UDA, because this is an area where there is a licensed, that they're not allowed to provide legal services, but they are allowed to help with the forms, and they are allowed to potentially help with some of the pre-litigation work. I don't know exactly what they're allowed to do. Obviously, it's not legal services, but I'd be interested to hear, if the UDA program is working and what's working, or what their recommendation would be, and if it's not working, why.
Ira?
Yeah, pardon me for raising my hand so many times. I do this work just about every day for the last 9 months, so there's a lot on my mind. And Amos just reminded me of something. There is one situation, it's not uncommon, where there's a lot of money at stake, even for a low-income person in an eviction, and that is if they have a, I'll call it rent-controlled rental unit, because as you can imagine, it's often worth a lot of money to a landlord to get rid of, bluntly, a tenant who has a rent-controlled unit, because under the law that was passed about 20 years ago, they can then raise the rent to whatever they can get. And there are there are settlements in 5 figures, 6 figures, sometimes. I'm handling a couple of those myself. I don't charge for that. Some lawyers could, and it could be a contingency fee for it. And there's also relocation money for that, and not just for rent control, but also for the many landlords who want to tear down their buildings and build something they could charge a lot more money for. There's relocation fees required there too. So, we can get information on that, or try to.
There's also some limited areas where attorney's fees are recoverable in UD court, and I think it would be helpful to hear about when that is, and if that should be applicable to paraprofessionals, what changes would need to be made that might require legislation. I'm not sure.
So is there anyone else from the subcommittee? If not, maybe we want to go ahead and hear from Jason. So I'll go ahead and, Jason, you're invited to speak.
Appreciate it. Just a really quick point here, which is, I think one piece of information that would be really helpful, on the tenant side, because most of them are not going to be able to pay fees, probably the best way that this, and I think this is true in Ontario as well, that this program is likely to benefit tenants, is if legal services organizations and other community-based organizations that work on housing issues, such as tenant rights organizations, were to hire one or more of these paraprofessionals. And so I think we would want to talk to people who, leaders of these kinds of organizations, to ask them, you know, would you consider, what are the circumstances in which you would hire one of these paraprofessionals? What would you want them to do, such that can really help shape the more detailed recommendation in terms of what tasks are authorized, possibly even what training, what kind of experience counts. So again, I think, you know, even if paraprofessionals largely benefit smaller landlords, I think that can, if not close the justice gap, very much help achieve more fair, more accurate, more efficient outcomes. And so I think that's a good thing. But in order to really benefit tenants, I think the way that's likely to happen is for legal services community-based organizations to hire them. I'm sure there are people out there. I have talked to at least one such person who would hire such people. And I think talking to those folks and having their assistance in helping shape the recommendation of what they would want a paraprofessional to do would be really important. Thanks.
Thank you. Okay. Amos?
Yeah, thank you, Professor Solomon, for that comment. I 100% agree. And I think one of the things this committee needs to struggle with and work through is, I think a lot of the legal services organizations that do housing work are opposed to or have significant concerns regarding allowing paraprofessionals to practice in this area. And so I do think it would be helpful to hear from them and understand their concerns, because I do think there probably is a way to have a trained, licensed paraprofessional doing work in support of what legal services is doing, and in support of, you know, representing people that don't qualify for legal services, and still supporting the right to counsel movement, which I think is very important. It's kind of a point in time, I would say, in California on the right to counsel movement. And so I think there's a lot of people. There's an organization in Los Angeles called the LA Right to Counsel Consortium that participates in the state-housed LA County. And I think we should hear from them about you know, what their concerns are and how they could be supportive of a program.
Okay.
Does anyone else have any suggestions, ideas, thoughts? We have a lot of information now that we're tasked with tracking down. I might reach out to some of you just to follow up on your ideas of who specifically to get in touch with. I'm trying to remember when our next meeting is scheduled.
It's Monday. I just looked.
Okay.
And you all should be getting an email from Justice Petru shortly. She has asked that chairs be appointed for each subcommittee. And so she's gonna appoint a chair for this and others. And I think what Linda and I will need to do is work with the chair to map out essentially kind of a roadmap for how we get from today to the April meeting with a recommendation. So hopefully we can look at that on the 8th, and based on whatever we're able to pull together, I think that will drive the agenda for the 8th. Meaning if we're able to get someone who's an expert on quiet title and clearing title, we'll focus on that. If it's someone who does UD work, maybe, and help us get into the weeds on that, or Shriver project. So we'll have to be a little bit flexible for the 8th. If that's okay.
Ira?
Yeah.
Ira has his hand.
Sorry.
Oh,
I'll
go
raise
ahead.
my hand, don't worry.
Sorry. Oh. Well, all right. I just simply, we ought to hear from the, I think, from the tenants union. There's the Los Angeles Tenants Union that has many chapters, and I think a central organization. And I'm a member of the West Side one. And we ought to hear from the leadership or others about how the tenants feel about this and information they can give.
Reba?
I had two suggestions. One is, and I discussed this with Linda before, that I want to bring in a subject matter expert from my office to, kind of talk about what we help with here and how we kind of came up with our scheme on who we assist and how we assist them. And then, and I think she can help us with when we get into tasks as well. So I wanted to put that out there. The premier legal services agency in our county that helps tenants is Law Foundation of Silicon Valley. And if need be, I can reach out to the directing attorney for the housing unit to come on and talk to us.
Thanks for that.
Thank you. Anything else? Okay, so we'll put together like our list of what we're going to work towards bringing back to you, and we'll see you on. And again, as Leah said, you should expect to get an email from Justice Petru about a chair. And other than that, we will see you on Monday in a week.
Bye, thank you.
Bye.
Thank you.
Thank you.
Thank you.